Good morning, everybody. My name's David Gooding. I'm the head of our National Accountants Professional Liability and Regulatory team, and I'm delighted to welcome you back to A Brief Account. I'm also really pleased to be joined by my partners, Taylor and Liam Burnett. Now, with the theme of A Brief Account in mind, we're going to provide you with some headline insights on a broad range of themes and issues facing accountants and their PI insurers over the next half an hour. We're going to look at some trends with a special spotlight on audit claims and prosecutions, as well as claims against insolvency practitioners. We'll also sprinkle in some legal cases as we go along. And then we'll finish up with some observations around some topical policy coverage and disciplinary themes. Now, there will be a Q&A session at the end, so please do fire off any questions you might have as we go along in the chat box, and we'll do our best to pick these up at the end. If we don't cover them at the end with time in mind, we will email you with some thoughts if we have your email address. Now, claims against accountants have been broadly and largely benign. It feels like we've been saying this for many years, and they have been like that certainly since the last recession. Now, whilst premiums did harden over the last couple of years, anecdotally, I'm told they seem to have levelled out. Now, with that sort of backdrop in mind, that all said, in our experience over the last 12 months, we're probably seeing a broader range of claims against firms, which a few years ago would have been dominated by underlying tax planning type claims. Now we've seen certainly an uptick in relation to claims arising out of corporate, insolvency, and of course audit. We're also seeing a lot more complaints to the regulator alongside civil claims. Let's turn to some of these trends in more detail now. We're going to start with Taylor and Audit.
Thanks very much, David. One of the trends we are seeing relates to the continued and increased criticism of firms conducting audits. So first of all, I'm just going to look at what an auditor does. The purpose of an audit and an auditor is to inspect an organisation's financial accounts to ensure they're correct, that they comply with the law, and then sign off on those accounts. An auditor will use a variety of different techniques to investigate and obtain assurances that the statements being made by the organisation are correct. And there are many, many regulations and technical standards that have to be complied with in conducting an audit. So what triggers an audit professional negligence claim? Well, when businesses fail or are considered unviable as a result of, and most often, fraud or dishonest conduct, it's inevitable that those professionals who may have deliberately or inadvertently facilitated this are looked at closely. And scrutiny of those roles and the conduct undertaken by the auditors in discharging the duties may uncover evidence of negligent conduct or fraud and may offer an opportunity to get back some of the financial losses that have been incurred. So what types of professional negligence claims against auditors do we see? Well, as I've mentioned earlier, typically this will relate to a failure to spot a fraud on the part of an employee or on the part of the management. And this is frequently the case in the claims that we deal with. An example of one of the claims that we have dealt with involved a failure to spot a director's fraud, both when the firm was instructed to prepare the accounts and also subsequently when carrying out the audit. This happened over a number of years, and there were many opportunities to spot the fraud. Now, the issue we had to consider when defending the firm was whether it was so obvious that an auditor would have spotted the issues, or whether the steps taken by the insured firm were reasonable. We also see third-party claims. So that is claims not brought by those who the auditor directly owed a duty to. And this is an example of a case that we've seen relating to this was where a firm had acted as an auditor in relation to a firm who had had a large financial penalty against it. And the claim was to be brought in the event that the firm could not meet the financial penalty. So this raised some really interesting issues in relation to duty, and also because the claim was brought by a third party. It's really very difficult in relation to third party claims to make out, and they'll need to establish that the insured firm had assumed a responsibility in relation to that, and the audit was relied upon to the third party's detriment. And these can be really difficult hurdles to overcome. A key aspect of most audit claims will be expert evidence. And that's expert evidence both in relation to breach, but also in relation to quantum. And it can make it really very difficult and very expensive to defend claims against auditors. And that expert evidence will often be required at an early stage in the case. In terms of professional negligence, claims arising from audit are few and far between, and they generally make up less than 10% of claims across the professions. We don't see them as often as claims against other professionals, and they are smaller in volume, but when they are brought, they can be really, really big indemnity limit busting claims. And we are seeing them appearing more frequently than they are. So in terms of the factors that are impacting the frequency of claims, there are a number of different ones that I just want to touch upon. So first of all, the pandemic, secondly, some of the recent cases, and third, the economic downturn, where we tend to see claims arising. And all of these factors may mean we don't see the claims arising for some years as they start to flow through. So just briefly taking each in turn. So in terms of the pandemic and some of the impacts that this has had on audit, well, one of the main issues relates to site visits, where audit firms may have been unable or restricted in the way that they've been able to carry out site visits. Related to this is the hybrid way of working, impacting on the late or non-filing of documents, and also the challenges from hybrid working in relation to supervision, which is a general theme across the professions, not just accountants and auditors. Other issues relate to a failure to comply with digital bookkeeping and a continued reliance on paper-based systems. So that's the pandemic. So in relation to the cases, there are a couple of cases which have also impacted on the frequency of audit claims, and that's the Manchester Building Society Supreme Court case against Grant Thornton in 2021, and the Asset Co also against Grant Thornton the previous year. And these cases represented real unwelcome developments in the law for the audit profession generally, but they've been well received by the victims of some of the negligent audits who've suffered losses caused by the auditors' failings. And this really is encouraging more claimants to bring claims than they otherwise might have done. Now, the professional negligence claims are separate from the fines or rebukes the regulator might have made on the firms in question. And the failed audits have generated some really big headlines. And if you have a look at the next slide, this will show some of those headlines. And these are mostly from the Big Four, mostly KPMG, also Grant Thornton on there as well. But these relate to fines which have been imposed by the regulator, the FRC, which has a public interest role in investigating and holding firms to account. This really shows the extent of some of the fines that have been generated, really big, significant numbers. In the year ending September 22, the FRC gave record fines of 33.3 million, and that's a staggering sum, and it's a 77% increase on the fines of 18.7 million the year before, but was largely down to the really big fine given to KPMG for its role in the audit of collapsed giant Carillion, and you'll see on there that that was 14.4 million, and that was last year. So this is also consistent with the FRC's annual enforcement review, which showed an increase in audit failings and an increase in the level of sanctions and the number of cases that needed sanctions. And this is a reoccurring theme in relation to the audit investigations, where the FRC found issues in relation to lack of professional skepticism and insufficient audit evidence as coming the top two things which came out in their review. These conclusions are also supported by the conclusions of the ICAEW, which found that 24% of the 1,000+ audits checked in the past year needed some improvement. So a quarter of audits still not being satisfactory. The FRC fines are sending a real clear message to the accountancy sector and audit firms to really up their game and drive home that improvement in audits needs to happen. So what might be on the horizon in relation to audit? Well, as I mentioned earlier, we anticipate an increase in audit claims arising from the pandemic, the economic downturn, supported by the recent cases. But this is also balanced against the general feeling that the quality of audit is increasing. And this is driven in part by the message being given by the FRC in the huge fines being handed out and the desire of the same firms not wanting to be in the headlines any longer, but also by the procedures in place to drive change and improvements across the profession. So linked to this are the long-awaited government plans to overhaul the audit sector with a view to replacing the FRC and setting up a new, more powerful regulator called the Audit Reporting and Governance Authority, ARGA, with this new entity having increased enforcement powers. And this has come about really from the government's Restoring Trust in Audit consultation and proposals for reform last year, the purpose of which was to encourage greater accountability to the big businesses and address the dominance of the Big Four following the collapse of BHS, Carillion, Patisserie Valerie, and forcing the Big Four to share audit work with the smaller firms, with a view to having more competition and better choice. As well as this is the intention that the new governing authority will be able to set standards for enforcement committees in relation to the appointment and oversight of auditors. It was hoped that these would take place during 2023, but it's expected the changes themselves are likely to come into effect in 2024. So watch this space for what comes next. I'll pass you over now to Liam, who's going to look at insolvency practitioners.
Thanks, Lisa, and good morning, everybody. So you might ask, why am I talking about insolvency practitioners in an accountant's general liability roundup? Well, because many of them are also qualified accountants who are likely to have professional indemnity insurance, which is written on an accountant's wording. And on top of that, we're also seeing more claims being brought against IPs. So hopefully this is topical. And the good news is that those claims are often defendable. Now, an insolvency practitioner or an IP is appointed to act in relation to an insolvent individual, partnership, or company or corporate entity like an LLP. The duties and powers will depend on the nature of the appointment, and they derive from a mixture of common law principles and legislation, the latter being the Insolvency Act 1986 and the Insolvency Rules 2016. And running alongside this legislation, we have the Statements of Insolvency Practice and the Insolvency Code of Ethics. And like any professional, the IP must exercise high standards of care in the exercise of their duties. When claims are brought, because this is a personal appointment, the IP will generally find the claim is being brought directly against them personally. And it's often alleged that the IP has either failed to exercise their powers with a requisite standard of care, or perhaps the IP has gone too far and they've exceeded their authority. Now, the complainant doesn't always have to issue separate Part 7 proceedings. Instead, they may have grounds to make an application in the relevant insolvency proceedings in which the IP has taken appointment. That said, the court is often unwilling to interfere with commercial decisions taken by an IP unless there's evidence of bad faith or negligence, although that won't necessarily stop claims from being brought. So, what specific duties are owed? An IP must always operate with integrity and is under a duty to exercise reasonable skill and care, and it is judged by reference to the reasonably competent IP, having regard to the role employed at the time of the relevant conduct. And as I've already mentioned, the duties owed will depend on the nature of the appointment itself. Next slide, please, David. So, for example, consider the main differences between the roles of an administrator and a liquidator. Administrators are officers of the court, whether they're appointed in or out of court, and they must achieve one of the 3 statutory objectives. So the first priority is to rescue the company as a going concern. If they can't do that, then they need to achieve a better result for the company's creditors as a whole than if the company was wound up. And if they can't get that over the line, then they need to realise all or some of the company's property to make a distribution to one or more secured or preferential creditors. Now, the administrator must act in the interest of creditors as a whole, but absent the existence of some special relationship, the administrator does not owe duties to unsecured creditors. And as the company's agent, the administrator is not personally liable for contracts made by the company in the course of the administration itself. However, the administrator does owe fiduciary duties to the business, including loyalty, to prevent conflict arising, not to make an undisclosed profit, and to act within their powers impartially and in good faith. Finally, they've got to perform all these functions as quickly and as efficiently as reasonably practicable. Now, in contrast to the administrator, now turning to the liquidator, it's only where the liquidation is compulsory that the liquidator is subject to the control of the court. The main duties of a liquidator are to collect and realise assets, then distribute proceeds to creditors with any surplus paid to whoever else is entitled to it. In that regard, the liquidator must test the credibility and viability of creditor claims. They also need to investigate the conduct of the business, including that of the directors, as the company may have claims that it can bring which are classed as being assets of the business. Unlike an administrator, the liquidator is not an agent of the company, and that's because they take over from the directors and control the company. In effect, they're in control of the principal. So hopefully that gives a brief overview of the different duties that are owed by liquidators and administrators. And I want to move on to have a look at some of the drivers for claims. So obviously, the economy is a big driver of the claims. And looking at this slide, you can see insolvencies are on the rise. The total number of company insolvencies registered last year was just over 22,000, and that's the highest number since 2009. It's 57% higher than the same figure for 2021. The growth of litigation funding and the development of the AT insurance market are further factors. Ironically, the same litigation funders who have supported IPs in the pursuit of claims are now underwriting the very claims that are being brought against the IPs themselves. There are also increased numbers of litigation investment companies purchasing claims from insolvent companies and individuals, paying an upfront premium for an assignment of the right to bring a cause of action, and sometimes even agreeing to share a return of any recoveries made. So those are the main drivers. My last stop, before I hand over to David, is to look at some interesting developments in the case law. And I want to look at the three cases shown on the screen in particular, which are all important. So that's Edengate Homes, Nicholson versus Hardy, and Absolute Living Developments. In Edengate Homes, the case involves substantial claims against a family who were all directors and shareholders in the company, but for transactions at an undervalue, preference, and misfeasance. Now, there was no funding to pursue the claims, so the liquidator assigned the claims to a litigation funder for a £30,000 upfront premium and a share of recoveries. One of the family members who didn't want the assigned claims to be pursued against her or her family was also a creditor, and she claimed to be a person aggrieved by an act or decision of the liquidator within the meaning of the Insolvency Act. And she sought to challenge the assignment. She wanted it to be set aside. She argued that the liquidator had failed to test the market properly or offer her the opportunity to purchase an assignment herself. Thankfully, the court disagreed, taking the view that the creditor had no standing to bring the claims because her interest was adverse to the creditors as a whole. Looking at the merits of the liquidator's decision, the court was only prepared to interfere if the decision seemed perverse, which in this case meant so utterly unreasonable and absurd that no reasonable person would have done it. And there was no evidence here that the liquidator could have secured better terms elsewhere, or that a lawyer may have been prepared to run the claims under a CFA. In Nicholson versus Hardy, a creditor sought an order for the liquidator to contribute to the assets of the company. But this was because, according to the creditor, the liquidator had wrongly concluded, albeit on advice, that the claims the company had were not worth pursuing. As against the liquidator, the claim was struck out, and the court confirmed, firstly, that the liquidator owed no duty to share the legal advice that it obtained, and secondly, there was no obligation to pursue claims without funds to do so. Now, this is a helpful decision, and it's good news for IPs and their insurers, as one of the key areas that third parties often attack is when the liquidator hasn't properly considered the value or merits of claims that the company has. The complainant often asks to see the advice that the liquidator has received, and we've even seen complainants ask for a copy of the instructions that the liquidator sent to the professional advisor just to check whether the advisor was properly instructed and asked the right questions. So this is a really useful decision to know about. Finally, we still see claims being brought where it's alleged that the liquidator has sold assets at an undervalue. In the case of Absolute Living Developments is a helpful reminder of the kind of defence arguments that should be raised. So in this case, the liquidator's decision to sell properties within a development as individual properties rather than as a package of properties was criticised. The creditors sought injunctive relief to prevent the sale of a single property for 3.2 million on the basis that they contended if all the properties were sold together as an entire development, the liquidator could have got around £18 million. The court rejected their argument as the company did not own all of the land, and so the liquidators could not sell the development as a package. And also a further obstacle standing in the way of the liquidators was the fact that they would have to disclaim lots of leases in order to sell the plots together. But more importantly, the liquidators had obtained advice from 2 reputable agents, and the court concluded it was more likely that the liquidator was acting in accordance with that advice as opposed to ignoring it or acting against it. The court also concluded that unless the contrary were illustrated, a liquidator is presumed to be acting professionally, honestly, and competently. So, in conclusion, whilst we're beginning to see more claims being brought against IPs, the court still seem very reluctant to interfere with commercial decisions that are taken. And there's good reason for this, because IPs often have to make difficult decisions under pressure and without access to full information. They must still exercise their discretionary powers as best they can and balance the interests of various different parties. And this is a difficult balancing act. So when there's criticism, that can often lead to claims. I suppose the key takeaway for IPs is to ensure that they're taking advice in good time, and that when they have an important decision to make, they have it in mind that that decision might be challenged at some point in the future. So it's really important to be able to explain the rationale behind it. So that takes me to the end of my section. Thank you very much for listening. I'm now going to hand over to David to talk about some of the policy coverage and regulatory issues that are hitting his desk.
Thank you, Liam. So as you'll know, the ICAW minimum terms are hardwired into most accountants' policies, and they're largely policyholder friendly. But there are some really strict stipulations for firms around, for example, the amount of excess that they're allowed to carry, around provisions around defence costs. Defence costs have got to be on top of the excess and on top of the indemnity limit. There are strict indemnity limits. These are usually 1.5 million each and every claim, or in the aggregate for most firms, depending on their turnover. There's also the 50 principal rule, so that a firm with under 50 principals, and we're talking about equity partners here, by the way, firms with under 50 principals, they've got to obtain cover that's compliant with the minimum terms. So the big firms tend to get their own cover. Now, why is this topical? Why are we talking about this? Well, these policies come at a cost, these gold-plated policies. So for smaller firms, and especially those with a poor claims record, they might struggle to renew and run the risk of being punched into the assigned risk pool, the ARP, at high cost, or otherwise have to seek a dispensation from the ICAW for a non-compliant policy and have the regulator looking at them through the spotlight. At the other end of the scale, conversely, you've got the situation where sometimes you have much larger firms, still with under 50 principals, but with very high turnovers and sometimes quite risky practice areas. They're facing really huge premiums for minimum terms cover. This has become more prevalent recently, where you have large departments demerging out of big firms. So some of the big top 20 or top 30 firms had departments demerging out of them and creating new firms. Now, previously, those departments had run within the bigger firm that had its own non-minimum terms cover because they didn't have to get it, usually through a captive. New firms created, and they have to go out into the market and obtain minimum terms cover for the first time without any sort of independent trading record. That can be difficult. So you can see for some policyholders at different ends of the spectrum, there are some tension within the rules. And it's interesting that the ICAW is carrying out a review of the MTC and just stress testing their fitness for purpose. So watch this space over the next year or so, just to see where this is going to go. Just moving the discussion on slightly, despite the strict terms in these policies, you'd be surprised how many coverage issues actually still arise. And I just wanted to look at one of those, and that's around dishonesty. And you'll remember from previous talks and your knowledge that insurers, they can decline cover for a minimum terms policy in respect of dishonesty, when the claim arises out of the dishonesty of all the partners in the firm. Okay. Now, with that in mind, it is surprising how many claimant solicitors still raise dishonesty or recklessness when drafting a letter of claim or particulars of claim against a firm, especially a firm with only one or two partners. They're then really surprised, and I've seen a lot of this over the last year, they're really surprised when insurers reserve rights and investigate cover. And this is delaying the potential resolution of the claim. And practically, I've been at mediations as the coverage lawyer where you make the point that notwithstanding the fact that insurers and the professional firm are defending the claim and will do so, if the claimant makes out their own case at trial, there isn't going to be any cover. It will be a Pyrrhic victory. So in simple terms, what I've been finding is that the way that claimants are drafting claims these days, and in particular in circumstances where there is not an obvious mechanism for insurers to decline cover because the evidence isn't there, but the way this is happening is it does provide insurers with another negotiating angle. Turning back to regulatory, and Lisa's touched on this in terms of the audit prosecutions. I just wanted to mention that we've talked previously about a theme of there being lots more complaints to ICAEW at the same time civil claims are made, so mirror complaints. Well, I have to say those are continuing, and they've certainly been a big theme from last year for the cases that we've been dealing with. Why is that? I think claimants realise that they can pile on pressure in a civil claim by referring the firm to the regulator. It's also just far more common to be making claims to professionals regulators. Why is it relevant for us as defendant firms? Well, it's relevant because we tend to handle both matters for the firm and insurers. And whilst the representation costs for dealing with a regulatory complaint aren't typically covered in a policy, and they aren't in the MTC, insurers are usually fairly relaxed and fairly sensible about funding these, because it's absolutely crucial that the left hand dealing with the civil claim knows what the right hand's doing in exactly the same matter when negotiating with the regulator and responding to the regulator. And of course, the last thing you want is for the firm to be making comments in relation to the underlying circumstances to the regulator, which contradict what you're saying in the civil claim. So I think expect more of this. And I think you just need to bear in mind that ICAEW and the other regulatory body, the ACCA, will investigate poor service. They are not just looking at dishonesty or serious regulatory breaches. They will look at poor service. And it's indicative that disciplinary orders have increased by 15% over the last 12 months from the ICAEW. Worth also sort of finally bearing in mind on this point that even if you settle the civil claim in these parallel claims, even if you settle the civil claim, there's no guarantee that the ICAEW will close their investigation if you write to them and say the civil claim's been settled. They often will continue their investigation, and they'll have a regulatory duty to do that where it's appropriate. So for poor firms, there's often a double sting in the tail. Now, Lisa's talked about the relentless series of audit prosecutions against the Big Four. What are the implications of that for the professional and their insurers? Well, I think first of all, as Lisa said, I think we're going to see the FRC and ICAEW spotlight shining very firmly on audit work carried out by a wider range of firms outside the top four. I think you're going to see that mistakes and errors are going to be picked up much more regularly. And there's a department of ICAEW, the QAD, which will sample audits from across the profession. Notably, last year, of 1,000 samples, they reckon about 25% of those were inadequate. So I think, one should expect to see more regulatory investigations, and they're probably going to spin off into more civil claims, and especially if we have a deeper economic downturn. Conversely, I think in the longer term, we're going to see and continue to see a much greater increase in standards, which will depress claims and hopefully depress prosecutions as well. And if you're interested in this, have a look at our webpage at the interview we did with Jonathan Pryor at Evening Partners. He's an audit specialist, for some much deeper analysis. So that's about as much time we've got to cover the policy and regulatory. Can I just round up the discussion today before we turn to some questions? In short, claims landscape remains largely benign. Whether we'll be saying that again in another 12 months if there's an economic downturn, I don't know. But I think we are going to see that uptick in claims against insolvency practitioners that Liam's discussed, and certainly auditors, both from a claims perspective and from a regulatory perspective, which Lisa's talked about, not least given economic uncertainty and the huge public focus on auditors. I think generally claims will grow if the economy tanks, but as I've said, that's very much in the balance. Also, we will see greater scrutiny by regulators of IPs and accountants, as well as investigations into conduct running parallel to civil claims. I don't think that trend is going to come to an end. That's just going to continue. I'll be interested also to see the outcome of any proposed changes to the minimum terms. I suspect, though, these aren't going to be seismic, given the importance of the minimum terms to the profession and the public. Thanks very much for listening to us. We do have some time for some questions, which my colleague Harriet Strevens will handle. And I will pass you over to Harriet now. I think there's a few questions coming through, Harriet.
There are, yeah. Thank you very much, David. Lisa, I wonder if I could start with you, please. You were talking about some reforms earlier on. What is it hoped those reforms will do to make things better that the FRC was not able to achieve, I'm being asked?
Well, that is a good question. The FRC, as I mentioned earlier, has limited powers and has faced quite a lot of criticism for its approach to regulating the audit profession. And whilst it's been able to award some significant fines, it's got more limited enforcement measures. And so the aim really is for the new regulator to take on the world of audit with increased enforcement powers, and its remit will really be to hold auditors to account and try and get better competition and improvement on standards across the sector. It will work with the ICAEW in collating some new standards to work to, so that there is a better oversight of audit, and really try to reverse the sort of real bad press and criticism that the world of audit has had in recent years. So there are some high hopes for some changes. So
we'll hold our breath in the meantime then. David, interestingly, on the back of what Lisa's just said, another question relates to the ICAEW. I mean, the question is, would they simply prosecute a firm on the back for unsubstantiated complaints? I mean, if that's so, it seems to be very unfair.
Yeah, I mean, that would seem to be very unfair. I think the ICAEW will look at a complaint if it comes in, and it'll typically be, as I've said, by a claimant or their solicitor. So they will look at the complaint. If they feel that it has legs, they will ask the firm of accountants to provide some observations. That's an opportunity then, Harriet, for the firm to set out its case, not necessarily in full detail, but some observations. And there's a prospect there in a really poor claim without any merit that the ICAEW will just close their file.
So as far as you're concerned, it's not common then for that to happen.
It's not common, no. I think probably in about, certainly the matters I've dealt with, when they hit my desk, they tend to be, on our desk, they tend to be pretty serious. So what will happen then is that they'll decide to investigate further, and then the firm will then have a further opportunity to set out formal response to formal questions. But there is an opportunity at that initial stage to knock a complaint out.
Thank you. Liam, question being asked is whether it's common for the liquidator to challenge the conduct of a different IP when they were acting as administrator over the same company.
Thanks, Frank. It's a good question. Again, I don't think it's common for a challenge to be made, but I do think that most liquidators will consider quite carefully past actions, actions of directors, past actions of a different IP holding office as an administrator over the same company. And there have been a couple of reported decisions in the last few years that have arisen from this kind of scenario. So especially where, for example, the administrator is appointed by a bank, and there's a perception that, or an allegation is raised by a body of creditors that the administrator might have acted perhaps against the legitimate interests of the company or the creditors as a whole in favour of the appointing bank. But it's something we see alleged now and again, where the company subsequently doesn't survive, goes into liquidation, and the creditors or directors think they've come off worse as a result of what the administrator's done. And they start to say things like the administrator had a conflict of interest, especially if they receive a lot of work from that appointing bank in question. So it's not a particular risk to be worried about, but it is something that we see cropping up now and again.
Yeah, I can see that. We've just time for one more question, and this is aimed at you, David, if I may, relating to the coverage and regulatory matters that you addressed. Just how does an insurer go about balancing defence costs and coverage defences in order to negotiate a better settlement, would you say?
Yeah, and that's an interesting point. So, I mean, insurers have to tread really carefully. I know this is an obvious point, but where they're dealing with a civil case and defence costs have been incurred and they're incurring coverage costs, they've just got to make sure that the left hand knows what the right hand's doing. It's exactly the same situation where they're dealing with a civil claim and there's a regulatory complaint. So in most respects, that's quite similar. So I think, but in terms of on the regulatory side, the costs that are incurred in dealing with the defence of the claim are usually mirrored with the regulatory complaint, because you would investigate pretty much the same circumstances.
Yeah, do you think you would have a split at insurers of different people dealing with different aspects of those sorts of issues?
I think you only would on the coverage side if you've got a coverage investigation, as opposed to the regulatory side, which insurers would just deal with. If there's a coverage investigation, it will be up to the insurer whether they want a separate adjuster. In my experience, it's the same person that deals with it. Yes. They just need a very clear guidance between defence and coverage. Any coverage information should not be passed to the defence team. Yeah. Because obviously the defence team will have to pass that on to the insured. And they've got to be upfront with the insured dealing with the coverage investigation. So the insured knows exactly what the position is in terms of reservation of rights, when it is possible to complete the investigation, and if it's not possible. And I talked earlier around the fact that sometimes a case will have to go to trial in order to identify whether the individual partners acted dishonestly or not. So it's just being upfront to the insurer so they know what the score is and keeping that clear demarcation between defence panel and coverage panel.
Thank you very much indeed. Well, that's all we've got time for the moment. So I'm going to pass back to you, David, to conclude our session this morning. Thank you very much for spending time to give us the answers to those questions.